Welcome to the very first episode of Between Hearings with CHM, your go-to podcast for all things legal. Whether you are a seasoned legal professional, a curious bystander, or someone seeking clarity in a world of legalese, tune in as we shed light on and uncover the hidden truths within the various legal matters. I'm Jessica Fox, a partner in the Employment Law Department of CHM, and your host. Today, we are diving into the case between Vodacom and Makate in relation to the Please Call Me service. This case has been running since 2008, some 15 years. And we will be exploring the implications of this case on the ownership of intellectual property, corporate responsibility, and employment law. I'm joined today by Ravi Govender, a partner in CHM's corporate and commercial law practice, and Craig Lawrence, the principal consultant at the HR and IR consultancy. Before we get started, please note that this podcast is a legal discussion on legal matters and does not in any matter constitute legal advice. If you have a pressing legal dispute, please consult with a legal practitioner. Ravi, you and I have had quite a few discussions on this case, and I know that you've been following the matter since 2008. So before we begin, I think perhaps maybe give us a quick summary of what's happened in this case and, where the parties find themselves now.
Good morning, Jess, and hello to the listeners. Thank you for having me on your show. So like you mentioned, this case has been dragged out for a long time, starting out in 2008, and the most recent judgment was delivered this year by the Supreme Court of Appeal. So it's quite a journey for the litigants in the matter. So basically where this started is from the applicant himself, Makate, was a trainee accountant at Vodacom during the early 2000s, 2001. And so he came up with the idea, and at the time the idea was called the buzzer idea. And then later evolved into Please Call Me, but the concept was there. And he proposed this to his manager, who then proposed it to the head of development at the time, Mr. Geisler. And there was communication regarding that, and promises were made to Makate regarding remuneration if the product launched. And so it ended up becoming one of the most successful products at the time. I'm sure Vodacom would defer with me, but I think it was rather successful for its time, and a lot of money was generated through it. And obviously, Makate didn't get what he thought was due to him, and so he approached the courts. Interestingly, also, he had left the employ of Vodacom 2 years after he started. And in fact, I think he waited another 4 years before he started making his demands for the claims that we now see. Mm-hmm. And so that really is the base of it. It first started out in the lower courts, in the Johannesburg High Court. The Johannesburg High Court actually dismissed. There was a full trial. It dismissed his action based on the fact that his claim had prescribed. And so if you look at the timelines, it actually did. And that's where it ended for him. And so obviously he challenged that. He took it all the way to the Constitutional Court. And the Constitutional Court then overturned that, looking at the issues of ostensible authority, the contractual nature of the arrangements between the parties, and the remuneration. The calculation of the remuneration was considered, which led then to the matter being referred back to Vodacom and Makate to enter into negotiations. Failing that, the CEO of Vodacom would then get involved. And that's exactly what happened. I think an amount of about 47 million was offered to Makate as remuneration for his idea, which he, of course, rejected based on his own calculations, and then approached the Supreme Court of Appeals, who then ruled that he's entitled to at least 5% of the revenue between those years, 2021 to about 2019. And the actual figure is unknown, but it's in the region of between 29 and 110 billion rand. And of course, now we see that Vodacom has taken the matter to the Constitutional Court.
And that's to dispute the amount that he's claiming he's entitled to.
Correct.
All right. Thank you, Ravi. That was a very quick summary of a very lengthy matter. Yeah. I understand that this case concerns, at the crux, the ownership of intellectual property. Is it correct to say that the case, however, is primarily decided on a contractual basis?
Yeah, that's a correct estimation, and it's quite interesting because you would think a matter like this involving an idea, an invention of sorts, would fall into the exclusive realm of intellectual property and the law that surrounds that. And so the way this transpired was very interesting in that it was based on an agreement, and the issue here wasn't that Makate. Well, initially there was a bit of confusion as to where this idea emanated from. I think the CEO at the time came out with a book in which he said that the idea came from him. I don't want to get into the details, but people can obviously look at it. He was leaning over his veranda at work, and that idea struck him, and he told the head of product development to run it. And of course, there's correspondence confirming that within Vodacom and also externally published, confirming that Makate was the actual generator of the idea. And so the dispute wasn't really whether it boiled down to whether it actually was Makate's idea or not. I think they accepted eventually that it was his idea. And so the issue of IP law and who was the originator of the idea didn't factor as much between the two parties eventually. And it all boiled down to now whether the contract or the oral agreement that was entered into between Vodacom and Makate was actually legitimate. And that's what the court had to deal with. There's legal terms regarding ostensible authority because the contract wasn't in the ordinary course. It wasn't a formal contract. It was sort of, Makate had an idea. He took it to the head of product development, who said to him that, if this gains traction, I'll speak to the CEO. I'll promise you, but also in the same breath, said to him that when you're an employee, you don't necessarily receive any remuneration, but irrespective, I'll speak to the CEO. So I think that created the confusion, I suppose, or the expectation in Makate's mind that he was entitled to this. So it did boil down to exactly what you said, that it's mainly regarding contractual dispute.
All right.
The thing that really interested me, which is not a employment law or an HR thing, Jess, is where the valuation came from. Because, these numbers that are being put on the table now are really significant. They sort of eye-watering numbers. But it all starts, I think the number they're talking about is 5% for the period. And those are the guidelines that have been used.
Yeah, period of 18 years.
Exactly. Where does the 5% come from? Who determines that the 5% is the right number? Because even if it had been 1%, it would still be a significant number.
Yeah. I think so. Makate himself, he initially said that he wanted 15%, but the figure itself wasn't agreed upon. It was said that we'll deal with it, and we'll let the CEO come up with a figure. And I think from that agreement, it flowed into the Constitutional Court judgment, because the question was why would you refer a remuneration calculation that's due to a third party to the very organization that's paying it, and because usually you'd want an independent to evaluate that. But I think the Constitutional Court took into account the original agreement that was made, and it was always the case that the CEO of Vodacom would determine that. In terms of, look, it's in our estimation, it's quite a lot of money. It's obscene amounts of money, but it's because the product itself did so well. We could be having a different conversation, or maybe people would feel differently if the figure was 1 million or 2 million, but because I think it's just the number issue, and of course we tie it emotionally to numbers, but it did so well. It generated millions, literally millions of rands. At one point, they were sending 2 million please call me messages a day. And together with that, it wasn't just the please call me, they attached ads to that. And so the revenue, just skyrocketed. So, I think, in terms of the calculation based on what they made and how the product was marketed, it's the correct way. Of course, the amount itself, that doesn't sit well with a lot of people, I suppose.
Seems like big money.
Yeah.
So as I understand, the issue of intellectual property was almost just abandoned because, as you said, they agreed upfront that he was the inventor of the idea, and there had been some promises made. I have, however, read some articles and papers that where the author suggests that the outcome of the case may have been different if they had argued IP law instead of contract. Do you agree with that, or do you think that the approach they adopted in this case was the correct approach?
Yeah, so I think the outcome would have been different because it is a matter of fact that MTN had come up with the idea, although it wasn't called Please Call Me, it was called, I think it was Call Me.
Yeah.
And the idea was actually patented during that same period, but prior to Vodacom launching their service. And so it was patented, and I think, it's in the public domain. The inventor itself was Ari Khan. He was actually an engineer at MTN, and he came up with the idea. And so, in fact, Ari Khan was, or I think MTN was scheduled to be part of the witness list to be called by Vodacom, and this is also documented. But for some reason, at the last moment, they were removed, from the witness list.
That's a very interesting, aspect to this case. I mean, I would think that would be almost a killer point to any of Makate's claims. Why do you think that this happened? I mean, why do you think they made this decision to pull Ari Khan as a witness?
Yeah, I think, it's not so much a legal decision. For me, it's obviously a business decision. Because, if in the market, Vodacom and MTN are seen as competitors. And so if you have a competitor trying to help you win a case, that's one that you probably don't want. The other point is that if MTN had to testify that this was their patent, where would that leave Vodacom and the revenue that they've already generated through this idea? Because the patent is actually owned by MTN, and so MTN would then have a claim against Vodacom. And I saw that questions were asked between the companies to the reason why they didn't pursue this route, which you've highlighted. And the answer was that, well, in this industry, in the telecommunications industry, it's not uncommon for companies to steal each other's ideas or piggyback off each other's ideas. And I think that's true, not just for Please Call Me. I wouldn't call it stealing, but they leverage and piggyback off each other. If you look at the market capitalization of both companies, Vodacom's around, last time I checked, about $9 billion US, and MTN is close, it's about $9.5 billion. They share the same market cap. Their revenue is the same. If you look at their product offerings, there's nothing that unique about it.
Competitive.
It's highly competitive, but it's similar in nature. In South Africa, you'll have people who are indifferent to Vodacom or MTN. You probably get people saying, well, I get better signal from this network than another, but in a different region, it's vice versa. So in terms of how South Africans view them, I think, getting into a big fight amongst themselves would not make business sense. And I suppose, they decided we're not going to.
Probably a bit embarrassing for MTN to come to the rescue of Vodacom.
Yeah.
All right. Thank you, Ravi. I think I just want to refer to the article that you actually wrote on this judgment. It's called Please Don't Call Me. I love the title. And for those of you that are listening, it's actually a really great article to read. It deals with several key legal and ethical takeaways from the judgment. The article can be found on Ravi's LinkedIn, but we'll also share the link with you. Of interest in your article, you touched on some critical questions about the ethical responsibilities of corporations towards individuals who contribute to innovative ideas.
Yeah.
Do you maybe want to share your thoughts around that? I think that's an interesting concept that's come out of this judgment.
Yeah, I think, we're moving into an era now, the fifth industrial revolution, where there's this collaboration between, when we talked about the fourth industrial revolution, it was all about the machines and the digital age, but now we're moving into an area where there's a dichotomy between customer service, employees, and the digital interface. And so I think for companies to thrive and succeed into the future, they should really start thinking about including their employees, because you have, for instance, Makate highlights the fact that, even though somebody sits in accounts, they could have a brilliant idea that could change the trajectory of your company. And I think if you foster that type of thinking and you encourage it, I think it's good for the individual, because you retain your people. And also, I think from a business point of view, you have this think tank where ideas are freely shared without people feeling, if I share my idea, they're going to steal it. And so I keep it to myself. And then I'm aggrieved and then I leave it. And so, you don't want that, the type of environment. So companies, I think, need to start thinking about, I'm sure Craig will highlight on this. This is more his field, but being a bit more proactive in terms of thinking towards the future of where this all goes.
And how to involve your employees in that process.
Correct.
All right. Thank you, Ravi. I appreciate that. That's really, really insightful. So Craig, you come from business, and I'm sure you are very familiar with the intellectual property clauses which are included in employees' contracts of employment. In summary, those contracts normally say that the ownership of an invention or an idea is vested within the employer, particularly where it was created during the course and scope of an employee's employment and for the benefit of the employer. Now, I had done some basic research into the intellectual property legislation, and we know that there's three types. There's the Copyrights Act, there's the Patents Act, and the Designs Act. And the issue of employee-made inventions and designs are dealt with to a very limited extent in the Patents and Designs Act, not so much in the Copyrights Act. And so I want to reference Section 59(2) of the Patents Act, which deals with some of the statutory limitations imposed on contracts of employment where employees make inventions or designs or come up with certain ideas. And those limitations are basically that if the employee has made this invention during the course and scope of his employment, then the employer is entitled to be assigned that ownership. But also such assignment can't be, we can't force the employee to assign ownership over something that they've come out with after a year after the employment was terminated. So we know that basically, or in my understanding, that the contract or employers are entitled to regulate how ownership of intellectual property is dealt with in their contracts of employment, subject to these statutory limitations. But what I'm interested to know, and from you coming from that employment background, is there scope, based on what Robbie's saying, and based on the judgment, to rethink how these clauses are drafted, and to rethink how we approach the issue in the employment context?
Thanks, Jess. Yeah, there definitely is. In fact, I don't think it's just opportunity. I think it's an imperative. It interests me that this Please Call Me case has been relatively low key in the employment space. I think the implications are significant. Starting with a comment on what Roby said, and then I'll come back to your issue. I think Roby spoke about the ethical aspect as regards to employees. I think it's even bigger than that. I think companies in this day and age, Roby spoke about the fourth industrial revolution and the fifth industrial revolution. It's beyond ethics as far as I'm concerned. I think a company that has growth aspirations and sustainability aspirations needs to encourage this. It's not a quite a static ethical obligation. It's an imperative. You need to encourage your employees to come up with new ideas, change processes, suggest inventions. So to me, it's important. And if you accept that as, first of all, as a strategic importance, because the other alternative is just to run away and to tie it up legally and to chase your employees away, scare them away from raising it, and rather secretly go to a competitor and try and sell it to a competitor. I think you've got to embrace the idea of innovation. So if you accept that argument, you have to relook at your clauses for a number of reasons. And it goes beyond clauses. You need to look at your processes and your systems and your procedures, not to sound too much like an HR person, which is what I am. A very interesting aspect which has been lost in the clauses as a start, and you used the term in the course and scope. If you go back to some of the very early, Robbie, when did this thing start? 2021, no, before.
2008.
2008.
The case started in 2008.
You go back to some of the early papers and the early articles. It was pointed out that Makate had the usual standard generic clause in his contract. That seems to have been forgotten, but it got lost because of the agreement, and I'll talk about the agreement in a moment. But Makate wasn't in inventions; he wasn't in research and development. It wasn't part of his job, so it was not part of the normal scope of course and scope of his duties. So the clause was, for all intents and purposes, useless because he was an accountant. He wasn't in R&D, or he wasn't an engineer or anything. So for a start, companies need to look at the wording of their clauses, and they need to contact a lawyer to understand how to craft that, given this, wherever this case goes. I think that clause, which we've all been using for years, is due for an overhaul. But I think the companies need to look at this more bravely, in a bolder way, and say, we actually encourage this. So how is this going to work in our organization? we will compensate employees, but they need to control. Vodacom have lost control of this whole valuation mechanism. Leaders need to know what they can say and what they can't say. That's where this thing started to go wrong with his name, Griesel. The fact that Griesel promised something with no context, no parameters to it, has opened the door to the point that we're now talking about billions in compensation. So I think that an organization should be encouraging innovation and inventions. It needs to look at the processes, the procedures and policies that go with it so that they can control this going forward, encourage staff, set some parameters around compensation, how it's going to be used, the timing at which they need to submit a claim, at which the invention needs to be commercialized. To what extent do they get compensated? I mean, there's no way Makate thought about ads and everything being added onto this thing. So I think companies need to, I hope I'm answering your question, Jess. I think companies need to look at this whole thing completely afresh on the back of what's happened, rethink their clauses, rethink their approach, how leaders encourage and engage these things, and look at the policies and the processes that go with it.
Yeah, I think that's absolutely correct. I fully agree with that. And I think Vodacom could have avoided a lot of trouble had they agreed to a compensation up front. Had there been a policy dealing with that this is what you'll be rewarded for an idea. But as you said, it was an uncontrolled situation, almost novel in a way. And it's now resulted in 15 years of litigation, extensive legal fees, I'm sure. And, a huge payout to Makate.
I would add, Jess, we're speaking about employees, and I hadn't thought of it before, Ravi, so you gave me the idea as you were talking about employees. Of course, in the modern world of work, employees are only part of the ecosystem in a company. There are consultants and advisors and suppliers. It's just come to me now, but possibly organizations need to think about how they engage consultants in particular in this process, because it could be a consultant, not an employee, who comes up with the next 3 billion rand idea. So what do you put in your contracts with your consultants, for example? How do you engage them and proactively manage possible compensation?
Yeah, I think that's right, Craig. Thank you. All right. I think anything else that you would like to add?
No, I think I'm probably repeating myself, but this should not cause companies to go into their shells. They really need to rather embrace this boldly than try and avoid these things.
Yeah, try and avoid it and rely on the clauses that perhaps don't necessarily cover them. In respect of these issues.
Intellectual property route is clearly the more effective and powerful route to go.
Yeah, I agree. All right, I think we've come to an end of today's episode, and I think, in conclusion, with everything that Ravi and Craig have said, there is certainly scope to consider how employee-made intellectual property must be dealt with going forward. Thank you, Ravi and Craig. I really appreciate you sharing your knowledge and expertise in this matter. It's most insightful, and I think many employers can benefit from this. If you've enjoyed today's episode and want to continue the conversation, or if you want to have access to more content, webinars, or articles, be sure to follow CHM and/or HRIR Consultancy on social media. You can find Cowan-Harper-Madikizela on LinkedIn and YouTube. Remember to follow, like, and subscribe so that you can be notified when we post new content. We love hearing from our listeners, so feel free to reach out with your thoughts, questions, or suggestions on future topics. Thank you for tuning in, and we'll catch you in the next episode of Between Hearings with CHM. Stay well.